Welcome back, everybody, to the Law of Contract. In this lesson, we are continuing talking about the terms of a contract, moving away from the terms which are expressly stated in the contract, i.e., conditions, warranties, and innominate terms, and moving on to examining the circumstances in which we might find a contract having terms which are implied into it, implied terms. In these next few lessons, final few lessons on the subject of contractual terms, like I said, we're talking about how terms may not necessarily exist in the contract themselves, but rather be implied into the contract by courts normally. So, implied terms, like it says here, don't actually exist expressly or explicitly in the contract. There isn't a clause 4 that is this term, for example. There is just this idea that a term may be implicit in the nature of the contract itself. And there are sort of two ways in which it can be implied into a contract. Terms can be implied by way of a court. A court may conclude that an implied term exists. There also might be customary reasons why a term is implied, given the facts of the particular contract and the particular market that contract is seeking to regulate. This may also be a way in which contracts may have terms implied into them. This is also something that would also be determined by a court, often when there is a dispute. You could also find ways in which a term can be implied using the Consumer Rights Act from 2015. Now, we're not going to spend too much time talking about the Consumer Rights Act in this series of lessons. We'll do one lesson on it, just covering the basic provisions. But for the most part, the Consumer Rights Act is going to be limited to a series of lessons that we will do in the future on consumer marketing law and commercial law more generally. Again, though, this is something that's going to be in the works in quite a while, so we won't cover it in too much detail here. So, when it comes to the work that a court can do in the area of implying a term, there are two main ways in which a court may be able to introduce implied terms into the equation. They can be implied either in fact or they can be implied in law. And we're going to focus firstly on the first of these, the implication through fact, in this lesson. We're also going to talk about a particular test that is applied in certain circumstances known as the officious bystander test in the next lesson, and then in the final lessons we will talk about the ways in which terms can be implied in law, and then finally finishing on looking at the other focuses in which terms can be implied, i.e. through the Consumer Rights Act. So terms implied in fact, what does this actually mean? Well, a term will be implied in fact where there are issues which are left out of the contract itself. It is as simple as that. So if there are terms that are left out of the contract itself, but owing to the issues which are omitted from the contract, a court may have to imply that certain terms exist in order for a contract to be operational. So if you have a contract, and within the contract there are various different express terms that say X, Y, and Z, but in order for X, Y, and Z to actually take place, to actually be able to be operated, there has to be another term that exists, but maybe this term isn't actually in the contract itself. Well, the courts would say that given the fact that this term that doesn't exist, that doesn't actually find itself in the contract itself, given the fact that in order for the contract to actually be operational, this term has to be there, then it is implied that that term exists. And it's also implied that the parties to the contract agreed to this term in order for the contract to be operational. It must be shown, therefore, that on a factual basis, terms had to be there in the first place if the contract was going to operate in the way the parties intended it to operate. And this strikes to the heart of the party's intention, because if the parties intended the contract to operate in a specific way, and in order for it to operate in a specific way, it would require the existence of this term that doesn't actually exist in the contract, then it means that, therefore, the parties sort of de facto intended for this term to be in the contract itself, given the fact that they intended it to act in the way that this term requires. A useful illustration of this is the case of the Moorcock from 1889. This case is instrumental in introducing a particular test for a court to imply terms into a contract. This is known as the business efficacy test. Essentially, a court may imply terms in fact on the basis that the existence of those terms are efficacious for business. So, how can we use this case to provide ourselves a useful illustration of this concept? Well, the claimants in this case had been the owners of a ship, and a contract had been in place which stipulated that the ship was going to be unloaded at the jetty by the defendant, the jetty of the defendant at least. While the ship was being unloaded, it was damaged at the jetty of the defendant. The argument by the claimant was that there ought to be a term implied in the contract that stipulated the defendant ought to take reasonable care in ensuring the safety of the ship. So, essentially, the claimant argued that they breached their contractual obligations in terms of taking reasonable care to ensure the safety of the ship. But of course, that is not a term that is explicitly in the contract. So the additional argument, of course, by the claimant was, not only is this a breach of the contract, but it was a breach of an implied term within the contract. That it was implied by everyone involved in the contract that this should be a certain reasonable care taken in ensuring that the safety of the ship was to be protected when the ship was at the jetty of the defendant. It was held by the courts that this term was indeed implied into the contract. It was done on the basis that the term itself would be efficacious for business purposes. It wouldn't make much sense to suggest that a term of this nature doesn't exist in a contract where people are handling where the defendant was handling essentially the property of the claimant, such that them not taking reasonable care would have left damage to the claimant's property. So, Lord Justice Bowen developed the view that where it gives business efficacy, a term may be implied in fact, but that this principle does not just imply terms which may be desirable, which is, in my opinion, somewhat unfortunate, given the name of the test is business efficacy, implies a certain amount of desirability when it's efficacious for something to take place. It implies that it is not something that is necessary or is something that is really something that is quite a significant requirement, but it does lean more towards the side of desirability. But of course, the title of the test does not necessarily speak to the nature of the test. So, given the fact that this was the defendants in this case had known about the fact that there was a low tide, and since there were the owners of the jetty, and since this was information that was not available to the claimants didn't know about the low tide, the contract must have included the implication that the defendant would have taken reasonable care to protect the ship. Because if not, then on account of the fact that the claimants did not have this information available to them, the defendants could have just acted in any way, and there would have been no recourse or any remedy for the damage that would have been caused to the ship itself. If not, the contract would fundamentally not be workable. It wouldn't be workable to suggest that the defendants would have been able to, the contract would have able to have been taken place, given the fact that it was a contract whereby we are talking about the docking of a ship and unloading at the jetty of the defendant. It wouldn't have been a workable contract if there was no provision at all, which ensures that there is at least a reasonable amount of care that is essentially implied onto the defendant in this case.